the possibility of us, the prosecutors, and even the defense to use Filipino language when the same is possible, because I understand that there are legal terminologies which are really hard to translate, no? This is because we understand that this is a constitutional process. This is not purely legal. What is at stake is the interest of the Filipino people. So it is our intention na lahat ng mangyayari during the impeachment trial should be understandable on the part of the ordinary Filipinos, no? And I wish to reach out as well through this opportunity to the mainstream media and even the social media. Let us encourage the accurate dissemination of information, no? And as a matter of fact, I reach out to the leadership as well. At ito rin ang gusto kong ilapit kay Kong Zia and the other members of the House who are from Visayas, from Mindanao. Let us come up with simultaneous translation of the trial which will be held starting on July 6. Sana habang nagtra-trial, meron tayong translation to as many dialects as possible in order to make sure that the entire Philippine nation is on the same page. After all, this is a constitutional process. We want the entire nation to walk with us as we start, continue, and conclude the impeachment trial. Thank you.
Thank you, Chairperson Luistro. To open the floor for questions, let us hear from Rosalie Cas of UNTV.
Good morning po, Kongs. Kongs, regarding po dito sa, kay Kong Gerville po, nag-increase from the number of 25 yun pong witnesses. Pwede pong malaman without saying or stating the details, ito po ba'y dahil dun sa panibagong ebidensya po na nakuha po ng House Prosecution Panel with regards dun sa undeclared wealth?
It is because we recognize the rule that only those witnesses whose names were submitted during pre-trial will be allowed to testify during the trial, no? So if before we're trying to limit corroborative witnesses, we're selecting only the most important witnesses, we wanted to make sure that all testimony will be presented in court, and that is why we considered other witnesses whose testimony are likewise significant, no? I am not very much familiar with I understand that's the comment of Congressman Terry Ridon. Perhaps that includes also the witnesses that he is referring to in support of the allegations on unexplained wealth. Ang malinaw po dito, sa ilalim po ng ating rules, kapag ang testigo, hindi mo na isama ang pangalan doon sa pre-trial, generally speaking, hindi po siya papayagang tumistigo during the trial. And that is why, as a matter of rule, lahat ng testigong isasalang mo, dapat yung pangalan, isumitin mo during the pre-trial conference. And their names must be included in the pre-trial brief.
Does it mean din po, Kong, na determined na po yun pong mga bank officials na i-invite sa paglilitis?
We have no communication with the bank officials. But since the proceeding in the Justice Committee, it has always been the intention of the House of Representatives to include the bank representatives and the bank documents among the evidence which will be presented by the prosecution team.
If I may add, in the pretrial brief, while the general rule is that we have to list down all of the names of the witnesses that we will be presenting during trial, we are allowed to withhold certain names for security and safety purposes. We are also allowed to make a reservation of witnesses as long as we are able to give a description of the witness and the purpose for which they will be presented. So regarding the bank officials, for example, it is possible that we will not yet say the names of these persons, but there will be a description of their position and or the purpose of their testimony.
In addition dun sa sinabi ni Kong Bell, no? In fact, it applies not only to witnesses, it applies even to documents which are not yet available during the conduct of pretrial, no? In simple terms, the parties are allowed to make reservation in the pretrial brief and during the pretrial conference, provided we give a reasonable description of who this witness is, what will be the nature of the testimony, and what is the purpose to be achieved by presenting this witness, no? Reservation is allowed during the pretrial, and the reason why it is being allowed is because of safety and security, that's one, in case of witnesses, and for documents because they are not yet available.
Last na lang po on my part. Dun po ba sa motion din po na isusumiti po ng House Prosecution Panel, may anything about the issue on Senate leadership? Because I believe po, any motion, for example, to resolve kung sino ang presiding officer, because sabi niyo po, Kong Gerville, kung kayo po yung tatanungin, mas dapat pong magkaroon na ng duly elected Senate President, pero wala po kasing session ngayon, so hindi makakapag-elect ng Senate President.
You were watching my interview. For the record, the House of Representatives already recognized the leadership of acting SP Win Gatchalian. As a matter of fact, we articulated already that we will be appearing before the impeachment court initiated by acting SP Win Gatchalian, who nowadays is the one signing the notices in his capacity as presiding officer, no? I expressed that concern because I understand that impeachment is a very sensitive matter. Why sensitive? You know what happened to the first impeachment back in the 19th Congress. We are of the humble position that we complied strictly the requirements for the second mode of filing an impeachment complaint and for transmitting the same to the Senate, no? That has been the general stand of the House of Representatives. But nonetheless, you know that later on, it was declared unconstitutional by the Honorable Supreme Court, no? Regardless of our strong position. So, with that in mind, it is really my concern that I hope magkaroon na ng duly elected Senate President. If it is acting SP Win Gatchalian, well, we will welcome that. If it will be someone else, we will welcome that because that is the judgment and prerogative of the members of the Senate. The reason is we are apprehensive that we might encounter another constitutional issue because we will be starting the trial and there is no duly elected Senate President. That is, of course, while we recognize the leadership of elected Senate President pro tempore and acting Senate President Win Gatchalian. Sana ma-address na yon para wala nang apprehension ng House about another possible constitutional issue to be raised in the Supreme Court.
Just in addition to that, I think it's not only the integrity of the Senate that we're talking here. It's also for the purpose of providing clarity to the people. Because in the coming days, once the actual trial begins, we anticipate that there's going to be a huge investment in terms of the people watching the impeachment trial. So for clarity and for purpose of having a Senate without a leadership battle, it's it's our utmost understanding and plea, and if we can appeal, that the Senate would have a legitimate, uncontested leader for the purpose of clarity of the public.
Clarification lang po, sorry. So, ayaw nyo pong mag-start ang impeachment trial unless ma-resolve yung issue sa Senate leadership?
That is just an expression of our apprehension. But we submit, of course, to the jurisdiction of the impeachment court under the current leadership, no? Kung meron silang notices for hearing na, we will appear. That is just an expression of our apprehension that it will be best na magkaroon muna ng duly elected Senate President before we proceed to trial. No, I have no intention of formalizing that concern.
Thank you, Rose. We go now to Haji Camino of Brigada News.
Hi, Kongs. Good morning po. Follow up lang po dun sa plan na or sa call na magkaroon ng translation sa iba't ibang dialect. Paano po ito gagawin? Is it through the communities po ba? It will be held sa mga communities or sa mainstream media? Paano po ba yung magiging execution po nan?
I think that's an ongoing discussion that we're having with the comms team. Kasi what we intend to provide to the public is the widest information, easy to understand for the public, for our public, no. Kasi tama pa yung sinabi ni Chairperson Jinky na in the coming days, once the impeachment trial begins, the audience will be we will be hearing technical legal terms that are not necessarily quite understandable, easily to understand by the public. So those are the things that we also want to explore. Ang intention po talaga natin dito is mabigyang serbisyo ang ating mga kababayan na maintindihan nila ang pinag-uusapan sa impeachment trial dahil matagal na po ito pinag-uusapan at deserve po nila malaman ng katotohanan.
At gaano po kayo ka-confident kong na through these means or kumbaga way of communicating to the public, paano po siya makakatulong not just to secure conviction of course, but para po mas maipabatid sa taong bayan po yung kahalagahan ng impeachment process?
Well, una-una para sa kanila ito kasi ang nagsasalita po dito ay ang ating konstitusyon. Ang konstitusyon, sinasabi naman po na parati po natin sinasabi na ang impeachment trial ay this is a constitutional duty given to the House to initiate and then for the Senate to try and decide. Nandun na po tayo dun sa posisyon kung saan ang Senado ay pag-uusapan in an open trial kung ano po yung mga allegations against the Vice President. Isa po ito, to remember, this is going to be the first time that the sitting Vice President will be tried in an open court, in an impeachment court. First time po ito. So this will also set the precedents in the coming years. Paano po ang ating mga kababayan, hindi lang makita nila kung ano yung actual na trial, pero kung ano yung mga pinag-uusapan na naayon doon sa spelled out ng Constitution na mga violations na constituting an impeachable offense. So, para po maintindihan ng ating mga kababayan, as a form of educating also our public, not only to provide them the services via informing them accurate information that would be easily understood by them, but it was also educating them and what are the allegations and what are the possible violations that would constitute an impeachable offense for the appreciation of the coming generations.
To Kong Jinky and Kong Bell, paano po kung halimbawang questionin ng defense team yung pagkakaroon po ng bagong ebidensya ng mga witnesses po natin? Baka, kumbaga, technicalin po nila na wala naman daw po sa House Committee on Justice hearings po yun, kaya naman sa articles of impeachment.
Well, we have said on many occasions that the evidence that we will be presenting are all either those that were in the articles, those that were presented during the Committee on Justice hearings, and all other relevant evidence that is in fact stated in the rules of the House of Representatives on impeachment proceedings. So everything will be relevant, everything will be related to the allegations or the articles of impeachment. Now, we have our pre-trial brief that we will be submitting today. Nakalagay naman po lahat dyan, except those that will be made under a reservation that we will make. But there will be at least a general description of all of the evidence that we will present. So, we follow the general rule that there will be no surprise witnesses or surprise evidence. We will lay out in our pretrial brief all of the evidence that we will present or those with reservations that we are allowed to make on anyway.
Opo.
Maliwanag ang nakasaad sa ating konstitusyon. The House of Representatives has exclusive power to initiate all impeachment cases. The Senate has exclusive power to try and decide all impeachment cases. And along those lines, binigyan ng kapangyarihan ang House of Representatives at ang Senado na maglatag ng rules regarding impeachment. It is very clear both under the rules on impeachment of the House and the rules on impeachment of the Senate that they can exercise compulsory process. This pertains to the issuance of subpoena ad testificandum, to compel witnesses to appear before the impeachment court, and subpoena duces tecum, that is for the production of documents. So regardless of the fact that the evidences were produced only during the trial, the position is that is very much sanctioned by the Constitution. The purpose of this compulsory process is to aid the Senate during the trial. The same way that the purpose of compulsory process in the Justice Committee is to aid the committee in determining the existence or non-existence of probable cause. It is therefore very much legal, lawful, valid for both the House and the Senate to exercise this compulsory process for the production of documents and for compelling witnesses even when this evidence were not part of the impeachment complaint or the articles of impeachment.
Okay, last question na lang po. Sorry, sisingit ko lang po itong topic na to. Kasi in an interview po si Mayor Benji Magalong was asked regarding, may sinabi po siya na around 90% daw po ng members ng House of Representatives are corrupt. Dahil po sa kumbaga part na daw po ng sistema, it's a way of system na raw po na kaya masasabing majority ng House members ay corrupt. Any reaction po to this? Thank you po.
Well, as public officers and public officials, we carry responsibility when we speak about certain matters, no? Not only to give clarity to the public, but with precision. When I say precision, it has to also be backed up by evidence, solid evidence, no? So we cannot dismiss that because we also do welcome any effort from any sectors in our society to call for accountability. In fact, the House of Representatives has been standing on the principle of accountability. We've been doing a lot of committee hearings. We've been doing a lot of inquiries. In fact, the Committee on Justice is one of the examples by which we can say proudly that the House of Representatives call for accountability of public officials. But accountability also should be coupled with the observance of due process. Due process demands that any accusations made against anybody or any institution should be backed up by a concrete evidence. So it is, to me, it is quite irresponsible and irresponsible and unfair to just brush the entire institution with single stroke and to say that 90% of the members are corrupt. What about those? We should be judged based on our individual work. There are 300 plus members of the House of Representatives. Each of us are directly voted by the people. And so I think it's also as a matter of due process, because we're talking about accountability. Accountability cannot stand on its own without also complying with due process. So it is not quite fair to just sweep the entire house with one branding. No, these are allegations such as this should be backed by hard and concrete evidence. So we welcome those people who are calling for accountability, but it should be precise and it should be targeted to a specific individual and not to destroy the entire reputation of the house, which, by the way, as opposed to that statement, the house has been standing with accountability. We've been doing a lot of work. We've been doing a lot of inquiries in order to sort out allegations of corruption. So, to me, we understand that the mayor is an advocate of corruption, but he himself, as an investigator, he knows that such accusations should be backed up by evidences. Let me just add, if he has names, it's better to name names rather than to attack the entire institution.
Okay. Sorry po, last na lang po, singit ko lang din po, sorry po. Last na lang po talaga. Tomorrow, meron pong Blue Ribbon Committee hearing na pangungunahan po ng group ni na Senator Alan Peter Cayetano, Senator Marcoleta, pero hindi po sa Senate premises gagawin. I understand parang sa labas po yata ng Senado gagawin. Any reaction na po na syempre leadership issues pa rin po, pero itutuloy pa rin po nila yung so-called Blue Ribbon Committee hearing po nila.
Well, personally, this does not reflect the position of the House prosecution team. But since you've mentioned about a separate investigation or continuing Blue Ribbon Committee, I don't think even within the Senate leadership, the current leadership now sanctioned this parallel Blue Ribbon investigation. It only validates court. And I think the people deserves clarity and closure on the subject matter that are being allegedly committed by the Vice President. So I think it's just a diversionary tactic, if you ask me, my humble observation, to create a parallel issue that actually would, in a way, sway the attention of the public. But the public knows, and the public knows that the primordial concern now of the Senate, since they have already convened as an impeachment court, is to exercise their exclusive power granted to them by the Constitution, because no agency, no institution in the government has that exclusive power to proceed with the impeachment trial than the Senate. So this is the priority of the Senate, and the people knows that this is the priority of the Senate and deserves to know the truth, and for a speedy trial also. No. So again, going back to that issue, just to give you a short answer, it only reinforces our earlier observation that this is just a distraction, a diversionary tactic, and a PR stunt.
If I may add, the prosecutors will not muddle our time with, the Senate leadership issues. But we recognize the leadership of Senate President Pro Tempore Gatchalian, as this has been recognized by Malacanang, by all law schools, by law professors, justices of the Supreme Court. And there is every reason to believe the interpretation of the Avellino versus Cuenco doctrine. So, as of the moment, we have been following the leadership of Senator Gatchalian, and we submitted our pleadings before the impeachment court under his leadership. Thus, while we recognize that it is within their right to hold such meetings, outside the Senate, they may do so, of course, but then again, we follow the leadership of Senator Gatchalian.
If I may add, yung gagawin nila, perhaps you can charge that to freedom of expression. But in as far as legitimate inquiry in aid of legislation is concerned, let us remember that we have the new leadership in the Senate. Everything that they should do in order that it will fall within the purview of a Senate inquiry in aid of legislation, it must be sanctioned by the leadership. Nonetheless, with all due respect sa kanila, it is a legitimate exercise of freedom of expression.
Thank you, Haji. We now recognize Annalise Berano of Bombo Radio.
Good morning po, Congressman. Representative Gerville, Luistro po, kung kahit sino po sa inyong tatlo. Ma'am, bukod po sa naging itong ebidensya na binanggit ni Representative Terry Redon, can you tell the public today whether there is a piece of evidence in your possession that has not yet been publicly disclosed and that you believe could significantly affect the outcome of the trial?
The least I can say is, sapagkat ito naman nun pa namin pinopronounce, yung bank documents, yung bank representatives, which even us, we do not have them yet in our possession. So during the trial, upon the subpoena issued by the impeachment court, the prosecutors, together with the other party and the Filipino people, together we will be witnessing kung anong ilalabas ng bank representatives along with the bank documents.
Okay, so magiging surprise evidence ito, ma'am.
Yes.
Okay. Ma'am, follow up.
Surprise in the sense na hindi pa nakikita. But of course, that's part of our list of documents to be marked. Yung sinabi ni Bel kanina, reservation of documents to be marked because they are not yet available as of the moment, no? That's part of the list of documents to be reserved in our pre-trial brief, but surprise in the sense that even us, we have not seen yet the bank documents and we have not heard yet the bank representatives.
Okay. Ma'am, follow up. Yung pre-trial kasi remain closed sa media. So what information will you commit to disclosing afterwards so the public can follow the proceedings?
That's one of my list of concerns which I will articulate during our pre-trial conference. One is the possibility of sharing what is happening with the media. After all, this is part of the constitutional process of the impeachment trial, no? Second, yung nabanggit ko kaninang open rule, whether it will be adopted or otherwise. By open rule, it means na even matters which are outside the direct and the cross may be raised during the direct and redirect may be raised during cross and recross, no? And then the dialect, translation to as many dialects as possible, na pinaliwanag din ni Kong Zia Alonto. And then the possibility of formalizing that the parties can actually use Filipino during the trial. That is for the better understanding also of our countrymen. And one more thing that I did not mention kanina, we wish to invoke the policy of substance over technicalities, no? Because again, this is not a purely legal process. Ang importante dito, lumabas ang katotohanan, and therefore, evidence should be presented, all of them, no? And should not be challenged always on technical grounds. Substance over technicalities. So these are the concerns that we will be raising. Kasama doon, yung possibility of you, the media people, from being allowed in the pre-trial conference. But of course, this will be the judgment of the impeachment court, no? Pwede lang namin yun i-pronounce, i-articulate, but at the end of the day, whatever will be the decision of the impeachment court, coming prosecutors and even the media people, we will have to submit to their jurisdiction and authority.
Ma'am, last ma'am for my part. Do you believe that this closed-door pre-trial helps or hurt public confidence in the impeachment process? Just a reaction.
Huwag kayong masyadong mag-alala doon sa ang media ay hindi inallow sa pre-trial conference. You know why? This is like a meeting, no? And this is very time-consuming because the parties will be discussing each and every offer of stipulation. Eh, yung sa amin pa lang, ang dami. Tapos hintayin namin ang sagot ng defense, admitted or denied. Same thing pagdating sa kanila. Iisa-isahin nila yung offer of stipulation, aaralin namin, sasagot kami. And then, with regards to the documents, there's a possibility na magkaroon din ng marking and this will take so much time. Ang sigurado, by the time na mag-i-issue na ng pre-trial order ang impeachment court, all the things that happened during the pre-trial conference will be manifested by both parties. Kung ano man yung stipulations ng prosecution na inadmit ng defense, we will manifest that during the pre-trial. Same is true with respect to the defense, dun sa stipulation of facts na inadmit ng prosecution. Even the list of our witnesses na napag-usapan during the conference, we will be manifesting this during the pre-trial. And all the documents marked or to be marked will be manifested as well. Not only by the prosecution, but also by the defense. In other words, lahat ng mangyayari or mapapagkasunduan during the pre-trial conference, ima-manifest yan during the pre-trial proper. That is before the issuance of the pre-trial order.
Thank
So,
you.
to add to that, you will not be missing actually anything. Dahil lahat ng mangyayari sa conference ay imamanifest ng dalawang parties and even ng impeachment court pagdating ng pre-trial proper. That's prior to the issuance of the pre-trial order.
Thank you, Annalie. We now call on Eden Santos from Net25.
Hindi po kami takot. In fact, that directive came from the impeachment court. It did not came from us. Nabasa na lang po namin yan sa notice for pre-trial conference and for the deadline of pre-trial brief, no? As a matter of fact, if the impeachment court will allow the media people during conference, we will welcome that, no? But, of course, that is not because they are against transparency. They are in favor of transparency. As a matter of fact, that is the very reason kung bakit merong impeachment trial. I think the reason is expediency. Dahil napakahabang proseso nitong pre-trial conference na ito, it may take 2 to 3 days and even more, no? At very technical ang pag-uusapan in the sense na hihimayin kung ano yung mga gusto naming ilatag sa trial, which ultimately ay makikita nyo din naman during pre-trial and trial proper, no? So, walang issue of transparency dito. Ang issue dito is expediency. Definitely, the impeachment court is for the transparency, and that is the reason why we will be holding this impeachment trial.
So, linawin lang po na prosec panel nanggaling? Ay, hindi po.
Hindi po. Hindi po. It was written in the notice of pre-trial conference. Nandun po nakalagay that it will not be open to the media. But like I said in a previous interview, we in fact as prosecutors in fact want it to be televised. I think the reason behind it not being televised is that the impeachment court thinks that this will be too tedious, too boring for people to watch. Ganito po ang mangyayari sa pre-trial conference. Kunyari, babasahin ang pangalan ng isang ebidensya, sasabihin, we will mark that as our Exhibit A. Our Exhibit A-1. A-111. Ganun po. Napakahaba po niyan and I think the impeachment court just wants to avoid to spare the people this boring process. But in any case, everything will be written in or summarized in a pretrial order that the impeachment court will come out with. So, hintayin po natin ang pretrial order na ilalabas po ng impeachment court.
Idadagdag ko lang, no, if just to assuage the fear of some, number one, that's correct, it's the call of the impeachment court, the honorable impeachment court, kung paano na magiging procedure sa pre-trial. Number two, if, for example, in the matter of transparency, if without, for example, without the court's direct order to disallow the prosecution to discuss, for example, after the pre-trial conference, what transpired during the exact pre-trial, andito naman po ang lead prosecutors, lead prosecutor at saka mga prosecutors namin na ibahagi sa publiko kung ano yung napag-usapan sa pre-trial conference without necessarily going into specific details. So generally, the House prosecution team would even ready to inform the public what transpired during the pre-trial conference. Assuming, for example, that there is no direct directive from the impeachment court not to divulge the information of what transpired. So, ready naman po ang House prosecution team to share to the public, may bahagi sa publiko, kung ano man yung mapag-usapan, ano yung mga naagrihan doon, ano yung kinontest ng mga ebidensya, anong inaccept ng mga ebidensya based on the stipulation of facts. So, ganun lang po. So, do not be fearful about, throwing a dark blanket for the public not to be able to understand. But later on, I'm sure the House prosecution team will provide the public the necessary information that they need.
Nakalagay na po yun sa notice of pretrial conference, so hindi po para kami ay tumutol sa isang notice na nilabas po ng impeachment court.
Kasi medyo kami nasabi. At kung kayo naman po ang magpapaliwanag after na dahil wala po yung media, hindi po ba sabi nyo nga ayaw nyo na magkamali ng pagbabalita, pagbibigay ng mga informasyon ng mga media. Kung hindi po namin makikita mismo yung pre-trial conference, hindi po ba magkaroon ng parang yung naratibo ng bawat kampo, yun po ang lumabas.
Bibigyan lang kita ng what I can assure the public with all due respect to the lead prosecutor and prosecutor, Jinky, do not fear of connivance. Just to go straight to your point, ma'am, wala pong connivance dito. Hindi po mangyayari yan. Nandun din po ang depensa. So, at saka, ang korte po, ang Honorable Impeachment Court po, ang nagbibigay ng notice. Tayo po, nagko-comply po ang ating mga prosecution team doon po sa direktiba ng Impeachment Court para mas mapabilis, mas simplify yung pag-uusapan sa korte. Kasi deserve din po ni Vice President Sara Duterte ang speedy trial. Kaya sisimplify po natin during the pre-trial conference yung pag-uusapan sa actual trial. So just to give you a direct, and you can quote me on this, there will be no connivance because the defense team will also be there.
I just want to state for the record, we are not against making the pre-trial conference open to public. As a matter of fact, we are in support of that. However, please understand, in matters concerning the conduct of the trial, the authority belongs to the impeachment court. Our obligation is to obey the impeachment court.
And lastly, in relation to that, kami pong prosecutors or lawyers, And we, as lawyers, are officers of the court. Nasa ethics po namin yan. Kailangan po namin sumunod sa mga direktiba ng bawat korte kung saan kami po ay haharap. And this includes the impeachment court. So if it is their directive that the pre-trial conference will be close to media, then we all will obey the impeachment court as officers of the court. Ang pagkasabi ko po, some Supreme Court justices, luminaries, yes, luminaries, Supreme Court justices said that the Avellino versus Cuenco ruling stands. I did not say that it is the Supreme Court as an institution.
So, as a whole, hindi pa naman po talaga siya ang nire-recognize. Some lang po.
There's a pending petition.
There's a pending petition, but there's no judgment on that.
Wait, that petition has been resolved already. Ang sabi ng Supreme Court, that issue on leadership is a non-justiciable issue because it concerns a political question. So ito yung tinatawag nating doctrine of political question, when it concerns the power of the agency which is exclusive to them, the Supreme Court will not intervene. That's how they resolved the petition before the Supreme Court. So it's resolved already.
It was also denied based on the lack of standing, if I'm not mistaken, lack of legal standing of the petitioner.
And in addition to that, ma'am, no, in addition to that, it's not even the House of Representatives recognizing the election of Senator Gatchalian as Speaker Pro Temp or other legal luminaries, members of the Supreme Court, academe, and all other sectors in our society, but the Senate itself. The Senate itself recognizes the leadership of acting Senate President Gatchalian. Kasi nag-i-issue na sila ng mga notices, yung mga staff mismo sa Senado ay dumadalo sa mga hearings na under the directive of the acting Senate President with the newly elected Secretary General and Sergeant at Arms. So it's not even us recognizing Senator Win Gatchalian, but the institution itself. There's already that recognition.
Of course, acting SP has been elected as Senate President pro tempore. And because of the prior declaration of vacancy of all positions, including the position of the Senate President, automatic. As Senate President pro tempore, he is the acting Senate President.
Salamat, Eden. Our next question will come from Jonathan Andalop, GMA 7.
Good morning po. Andito po ako sa gilid. Kung sabi ni Senator Lacson, only the prosecution and the defense can make a motion to reduce the threshold of 16 votes to convict an impeachable officer, in this case, Vice President Sara Duterte. Does the House prosecution team intend to make such motion para bawasan yung threshold na 16 votes to convict?
We have not actually discussed about that, us being a team, no? But I have expressed my position already that concerning the threshold for the purpose of conviction, it is important to realize that the Constitution and the laws are evolving. Why do I say that? Because the Constitution should be responding to the demands of time, just like any other law, no? And very enlightening itong nangyaring change of leadership sa Senado because it invited our attention to look into the doctrine behind Avellino versus Cuenco na in several occasions ay na-practice na rin ng Senate at nagkaroon na rin ng mga succeeding Supreme Court decisions along the same line, no? So, ang sa akin naman, let us anchor also our position on the mandate of the Constitution. Bakit tayo may mga senador? Primarily, the purpose is to represent the interest of the Filipino people. Kung ang ating senador ay nakakulong, nagtatago, nasa ospital, or nasa abroad, ito yung tinatawag ni Avellino versus Cuenco na beyond the coercive power of the Senate. And having said so, plus hindi mai-represent yung interest ng taong bayan, how are we going to consider them for the purpose of determining the threshold or the required number of votes? So, personal opinion ko lang. I believe that the doctrine in Avellino should be applied also in determining the number of votes required for the purpose of conviction. That is my personal opinion.
So dapat po bang bawasan?
With the current situation, yes. The same way that it was reduced in the election of Senate President pro tempore and the rest of the chairwomen of the different committees of the Senate.
Para sa House Prosecution Team, ilan ang base number ng senador na tinitignan niyo po ngayon?
This is my opinion. If the voting will happen now, it should be 22 as well.
If I may add, no, again, this is just an opinion, no. All of us has different opinions regarding the matter. Pero I think yung appreciation dapat talaga natin is we want the Senate which is operational, a functional Senate. No, we cannot have a functional Senate if some of the members will not be accessible in terms of passing their judgment through a vote. We're talking about impeachment trial where the sitting senator, senator judge, presence would be indispensable in determining determining the judgment by which one would have to arrive based on the evidence presented. So I think kailangan natin yung approach na yon to also be practical in order to establish our belief that the Senate is not just an institution sitting there to hear and to try and decide, but a functional Senate where the active members' presence are secured, a part of the deliberation, can actually arrive into a sound judgment because of their actual presence, by which these are the basis for them to pass on their judgment, either to acquit or to convict.
Doon po sa base number na 22, Kong Jinky, do you consider Senator Jinggoy as suspended already? Dahil siya po ay arrested na at nasa Sandigan Bayan?
Well, under the Plunder Law and the Anti-Graft and Corrupt Practices Act, when the public officials are charged as such, they are suspended from becoming a member of the Senate. So kung suspended ka, how can you attend? Are you still a senator on that particular occasion if you are suspended from your official duty? I think the answer is clear, no? And to add to what Kong Zia said, no? Meron tayong mandato sa Konstitusyon. And that is to trial forthwith, no? And if we hold the contrary view, it means that the constitutional mandate will be hostage by the different situations of some senators. Ilayo at wag ilapit, no? Kung yung nagsisirculate sa social media, mangyari. Sabihin natin 8 or 9 will be having their cases in court, no? Masususpend as provided in the Plunder Law and the Anti-Graft and Corrupt Practices Act. The required threshold is 16. So that will mean that it will paralyze the accountability mechanism. And we know, of course, that the Constitution is paramount. It must not be conditioned to the situation of our senators. This impeachment trial must proceed. The decision must be rendered, no? And the threshold must be fixed depending on the current situation of our Senate.
Kaugnay niyan, ma'am, sabi ni Senator Lacson, sakaling umabot ng 9 na senators yung makulong, 15 silang matira, hindi na raw matutuloy yung trial kasi paano nga man magko-convict kung kailangan ng 16 votes. Ang suggestion po niya, magfa-file ang impeachment court sa Sandigan Bayan ng leave of court para payagan yung mga nakakulong na senador na dumalo sa trial. Do you agree, ma'am, doon sa kanyang suggestion?
Well, my perspective is from the point of view that it is the Senate which has jurisdiction. We cannot speak for the Sandigan, we cannot speak for the Ombudsman, no? Of course, from the perspective of Senate yan, yung nag-hold ng impeachment trial, at hindi naman nila pwede basta panghimasukan what will be the decision of the Sandigan Bayan. I think it will be more appropriate to follow the doctrine of Avellino. After all, ibabalik ko dun sa mandato ng saligang batas. Dapat ang mga senador mag-represent ng interest ng sambayan ng Pilipino during that impeachment trial. And if you are detained, if you are in hiding, the question is, are you representing the interest of the Filipino? When in fact you cannot attend because of your personal dilemma, no? So, we cannot subordinate the constitutional mandate to the situation in the Senate. Constitution is paramount, therefore, it must be interpreted in a way to give light to the implementation of the constitutional mandate.
Last question na po. Doon po sa list of witnesses ninyo, more than 30, ilan po doon yung sa tingin ninyong high-profile witnesses na masasabi?
I cannot divulge yet, no? Ilang oras na lang naman at mafa-file na yung pre-trial brief. Pakihintay na lang po because our deadline is today.
Thank you, ma'am.
Thank you, Jonathan. From Rappler, Dwight De Leon is now recognized.
Hello po, good afternoon. Yung question, follow up po kay Congresswoman Jinky because, again, this is your legal opinion. So with 22 senators who are functioning sa scenario na yon, based on your legal opinion, does that mean for you, the conviction threshold should be reduced to 15? Given that...
Hindi ako magaling sa math eh. Para paki-compute mo na ng 2/3 of 22.
So that's 15. If 15 po,
Yes,
you would agree
yes.
po. Congresswoman Jinky, since this is also in the realm of possibilities, given na nasa 8 yung humaharap ng kaso, if one more senator is arrested or is subjected to an arrest warrant, the count would be reduced to 21. So in your legal opinion, if that happens, could the conviction threshold be further reduced to 14? Because 2/3 of 21 is 14.
What my position is to apply the doctrine in Avellino, no? So ang test natin, are they still within the coercive power of the Senate? If the answer is no, then the number should be reduced
To 14.
to 14.
Okay.
14 for the threshold,
For the threshold. If
21 for the baseline.
Yes, opo. And since nandito na rin si Congresswoman Bell, is that also an opinion that you subscribe to? Kasi sinabi kanina ni, I think, Kong Zia, na parang iba-iba syempre yung opinion ng prosecutors and it's not yet pag-uusapan collectively. So, Congresswoman Bell, is that also an opinion that you subscribe to?
Yes, it is an opinion I share with Chair Jinky.
And why po?
That's also the opinion I share with Kong Jing.
Okay po. Okay po.
Again, we need a Senate that is functioning. And for all of the procedures that the Senate will be doing, we need senators who are able to do their job. And if one is hiding, purposefully hiding from not only his job but from the people, then he shouldn't be included in the number when we count whether this is for quorum purposes or whether this is for the determination of conviction. So I share the same view as Chairwoman Jinky.
Also, Dwight, no, just to add to that, we don't yung sinabi ni Congresswoman Jinky, yung doctrine ng Avellino, it should not be applied kasi ito yung what we want is a functional Senate. And functional Senate meaning the active members deliberating in a very important subject matter, no? It should not also be looked at in the lens of impeachment trial, but there are also other cases, concurrence of treaties, diba? Concurrence of treaties, declaration of war, because it has to have a concurrence of the Senate. So if you don't have that if you don't apply the Avellino doctrine, which, by the way, the Senate is beyond this coercive power to, to require members who are, I think, behind bars or whatever, because of their incapacity by means of presence, they cannot vote. So what would happen to other issues? Not only impeachment trial, but, concurrence of the treaties. Treaties and then yung mga declaration of war, which requires the Senate for concurrence. So I think it's not only legal, but it also should be looked at in its practical sense. Because ultimately, what we want is for the Senate, as an institution, to deliver its mandate according to what the Constitution says.
I talked to a constitutional lawyer last week, si Attorney Paolo Tamasa, and he agrees with this emerging view about reconsidering the conviction threshold, but he said that it should be accommodated when we reach an extraordinary point, which we have not yet reached. Do you think that if one more senator is arrested, that is an extraordinary situation, an unprecedented situation that warrants the impeachment court to look to consider seriously whether we should reduce the conviction threshold?
Yes, as a matter of fact, even prior to the arrest of whoever will be the third, I believe that it should be interpreted already in a way that we will be able to address the present situation. No, I said earlier that the Constitution is evolving, the laws are evolving, the Supreme Court decisions are evolving, and by evolving, what I meant was hindi enough na meron tayong batas. Yung batas dapat tumutugon sa kasalukuyang sitwasyon. It should be able to respond to the current demands of time.
Another topic related to the pre-trial proceedings. We didn't have a pre-trial proceeding during the Corona trial, but meron po tayong pre-trial proceeding during the Estrada trial, and news archives suggest or indicate that during the pre-trial proceedings, the prosecution and the defense agreed to finishing the entire trial, the trial proper, within or by 34 days. It is a separate discussion if nasunod po siya, but is that something that the prosecution is eyeing to resolve during the pre-trial proceedings, kung gaano lang tatagal yung buong trial proper?
Part of the things to be talked about during pre-trial conference is the schedule of trial dates, no? And that includes, of course, the number of schedule that we will be needing for the purpose of presenting the prosecution's evidence. Same is true with respect to the defense. Tatanungin din sila, ilang trial dates ang kailangan nila to conclude the presentation of their evidence. So to your question, yes, the number of trial dates will be determined as well during the pre-trial conference.
Congresswoman Jinky, ballpark figure lang sa bahagi ng prosecution, ilang buwan kaya to, at least minimum? 1 buwan, 2 buwan, 3 buwan?
Ang aking estimate is if we will be starting on July 6, we will perhaps end by end of September 2026.
Sige po, ayun lang po yung questions ko.
I checked the Corona impeachment trial. It started January 12 to May 29. So that is equivalent to 4 months, no? So kung wala namang delay, tuloy-tuloy, tingin ko kakayanin ito for 3 months.
Sorry, may follow-up question po pala ako. May another question po pala ako tungkol sa, ilalagay niyo po ba sa pre-trial brief kung ano yung order of the presentation of the article of impeachment at ano po yung mauna dun sa apat? Tama,
Yes,
apat?
I think that's part also of the notice that we received to determine the order of presentation of the articles of impeachment. So, mamaya nyo na rin lang malaman after the filing of the pre-trial brief.
And lastly po, doon sa list of witnesses, alin po doon or witnesses sa patungkol sa ang topic, nag-expect ang prosecution ng matinding pushback from the Duterte camp? Kasi even during the pre-trial proceedings in the Estrada trial, I think based on news articles, may mga sinuggest yung prosecution at that time na isasabpi ng mga witnesses na inoppose significantly ng defense team ng Estrada camp at that time.
Without specifically mentioning the witnesses and the exhibits to be presented, but we anticipate that to happen in the article for unexplained wealth. Kasi naramdaman na namin yan during the Justice Committee proceeding.
So do you think po na i-oppose ng Duterte camp extremely yung inyong move to subpoena bank records bank officials?
We anticipate that. As a matter of fact, naalala nyo nung proceeding before the Justice Committee, they filed criminal case against us for violation of the alleged confidentiality in the Anti-Money Laundering Act. That was the time also when they filed a petition on the disclosure of transactions by the AMLC with the Quezon City Regional Trial Court as well. And if you will go over the issues raised in the petitions raised in the Supreme Court, kasama din yan. Yung confidentiality ng bank transactions, confidentiality ng AMLAC transactions. So, as early as now, we anticipate already that we will feel the challenge during presentation dito sa unexplained wealth.
Maraming salamat po.
Salamat, Dwight. Next is Isaiah Mirapuentes of Abante Billionario.
Hello po, good afternoon. Regarding po ulit dun sa 16 required number of votes na sinasabi nila, can we give a hope na whatever the threshold is, kayang-kayang maabot para ma-convict si Vice President Sara Duterte? If ever, ma-16 man, ma-15 man yan, kung ilan man.
You know, it is not for us to say, kung kayang-kaya abutin. As prosecutors, our sole job is to present evidence regarding the charges, regarding the articles of impeachment. So, yun lang po ang trabaho namin. Now, we leave it up to the Senate, who will be, of course, swayed by public opinion once we lay down our evidence. Yun lang po.
Also, as I understand, based on the Constitution kasi, 2/3 of all senators, can we explain to the public? Kasi nakalagay doon all eh. So, pakiramdam namin 24.
If you want to be literal, no? Ang sinabi sa Constitution, 2/3 of all members of the Senate. It did not say 2/3 of the 24 members of the Senate, no? So I think the use of all, and we can check perhaps this from the framers of the Constitution, is in order to give room to the people in the government, the senators, the Supreme Court, to interpret the same to a way that the constitutional mandate will still be given effect, no? Just like nowadays na may discussion tayo about how many is the threshold, how many is the quorum, and then we are able to see the doctrine in Avellino versus Cuenco. So I think these decisions came up because during the time they also anticipated things like this, no? Things which we are encountering right now. Basta sa akin lang, let us anchor our interpretation to the mandate of the senators. Are you still representing the interests of the Filipino people? If the answer is no, then the threshold must be reduced.
Pero Congressman Luistro, can you also explain to us anong magiging trabaho ng mga senador na, like for example, Senator Jinky Estrada, anong magiging role na lang nila at pwede nilang gawin during the impeachment trial?
First and foremost, sabi sa Plunder Law at saka sa RA 3019, Anti-Graft and Corrupt Practices Act, kapag na-filean sila ng kaso, suspended din sila sa pagiging senador. So, what function are we expecting them to discharge if they are suspended from their official capacity as members of the Senate?
Are they allowed to submit letter ba na magiging side nila for during the impeachment trial? Pwede po ba yun?
If we will be following strictly the provisions of the Plunder Law and RA 3019, while there is the suspension, they are not considered as members of the Senate.
Okay. Another question po regarding lang po sa magiging presiding officer ng Senate. May nagsasuggest pong senador na dapat abogado. Actually, according to Senator Ping Lacson, kung sakali raw pwede maging presiding officer si Senator Kiko Pangilinan at Chis Escudero. So tingin niyo po mas mabuti bang maging abogado ang presiding officer?
In all honesty, I don't see anything wrong about having a presiding officer who is a non-lawyer, like our acting SP, Win Gatchalian. Let us remember that the impeachment trial is not purely a legal process. It is sui generis. In one way, it is constitutional. In another way, it is administrative. And in another way as well, it is legal. What is important is for us to be able to ferret out the truth, no? Which means that the evidence must be given ample opportunity to be presented. And if we will always be challenged by rules on technicalities, rules on procedure, objections to the evidence which are being presented, it might defeat the purpose of this impeachment trial. Remember that what we are testing here is the fitness of the public official to continue holding office and not the criminal liability, not the civil liability. Diba? Ang sabi nga, after the decision on this impeachment trial, they can still be held liable for prosecution to whatever cases may be filed against them.
Last question na lang po from me. Yung regarding naman po dun sa additional evidence na inad natin, which is regarding sa unexplained, undeclared property ni VP Sara. Before sinasabi natin na overwhelming na yung mga evidence na nakuha during the House Committee on Justice hearing, can we say ba na mas mabigat itong bagong ebidensya? That's why dinagdag natin itong evidence na to dun sa mga list of evidence against the Vice President.
I said a while ago that the reason why we added names to the list of witnesses, documents to the list of exhibits, is because of the rule that witnesses and exhibits which are not included in the pretrial brief will not be allowed to be presented during the trial. So it's not a question of probative value or weight of the evidence. It is a question of inclusion of all the witnesses and evidence to make sure that we will be allowed to present them during the trial.
Thank you, Isaiah. Next is Ysabel Zamora of DCBB.
Magandang hapon po, Isa Umali po. First question lang po kasi nag-anunsyo na po yung Malacanang, inuutos na po ni President Marcos yung special session ng Congress on June 17. Yung House of Representatives po ba, may mga target pang gagawin or tatapusing mga trabaho? Thank you po.
Well, on yung ordinary committee hearings, ongoing pa naman eh. In fact, today, ang Committee on Education is holding a committee hearing. So tuloy-tuloy naman po yan. Since you ask about yung trabaho, we have already delivered out of the 50 LEDAC priorities we were able to pass on third and final reading, 20 plus, almost 26. So half of the LEDAC priorities. So if Malacanang requests for a special session, we anticipate and we welcome that.
And kayo po sa part po ng House, hoping din po ba kayo na dun sa special session na yon, mapaplansya na po yung gusot sa Senado?
Well, as far as the House is concerned, we maintain our institutional respect to our co-equal branch. If that would be part of the issues that they need to settle in the Senate, that is entirely within the decision of the Senate. But I also would expect that since if for example, Malacanang, nag-receive na ba tayo? Wala pa nung issue. Wala pa.
Ito yung nasa notice ng Malacanang na dapat matapos. And kay Ryan, tapos na dito.
Yeah.
Transmitted.
Yun nga, well, sabi ko nga yung mga LEDAC priorities na tapos na out of the 26. So, tapos na po natin, na-transmit na po natin yung sa Senate, yung Anti-Political Dynasty, X Act, amendments to the Universal Access to Quality Tertiary Education. So, if there will be a special session, again, if we ask us dun sa Senate leadership issue, That's entirely for the Senate to decide. But we anticipate that they should take that opportunity to finally settle the issue on leadership.
Lead prosecutor.
To your question, we can only hope and pray, no? But that is, of course, the prerogative and judgment that exclusively belongs to the Senate. We cannot meddle on the issues of their leadership, but we're hoping and pray that they will be able to fix it on the occasion of this special session.
Another pa po, no? Na-announce na po yung first batch ng private prosecutors. So when po namin maasahan yung second batch? At patuloy pa rin po ba, kasi may mga nagsasabi na dinadagsa kayo ng mga nag-a-apply, nag-audition na maging prosecutor. So yun po, kailan po namin maasahan yung second batch?
Totoo naman yun. The private prosecutors keep on coming to join the impeachment team. And we're happy about that because that is a validation that even private lawyers, mga abogado de campanilla, believe in the cause of the House of Representatives. They are joining us in our stand to protect and preserve and enforce this accountability mechanism, no? So to your question, kailan uli? Let us see this week kung pwede tayong mag-introduce ng next batch. But definitely, all of them will be introduced before we start our trial on July 6.
And last question na lang po, kumusta po kayo? Kasi po syempre, kayo pong tatlo. Kasi po, syempre, matagal-tagal na rin nating pinag-uusapan tong impeachment. I'm sure may mga personal challenges din po kayong nararanasan. Pero kayo po, ano po yung siguro mabigat na hamon na naranasan nyo, pero tuloy pa rin ito pong pag-susulong nyo ng impeachment? Thank you po.
The only challenge that I have is I do not have anymore the luxury of time of moving around my district. Dati kasi naiikutan ko lahat ng patay, napupuntahan ko lahat ng okasyon. That I cannot do now because I need to focus to our preparation for this impeachment trial. Nonetheless, ako po'y nagpapasalamat sa lahat ng aking mga kababayan from Batangas 2nd District. Nagpaalam po ako sa kanila until this impeachment trial is concluded. And the reaction is very much positive. Nauunawaan po ng aking mga kababayan from Batangas 2nd District what accountability mechanism is all about, as well as the significance of the constitutional mandate for this impeachment process.
Mabuti naman. Salamat sa pangungumusta. Actually, I think I can speak for everyone here. The volume of attacks and misinformation that thrown our way, isa yan sa pinaka-challenging. But these are part of the strategy of those who are against accountability, those who are against our job to against the members of the House Prosecution Panel to exercise their duly mandated constitutional directive to proceed with the impeachment. These are part of their effort to probably silence us, to scare us away. But sa amin lang, ang sagot namin dyan ay mas tumatatag po ang aming loob. Dahil we stand in front, side by side with the Constitution. This is a constitutional duty that we need to perform. So no matter the volume of fake news, attacks against us, we will not be silenced, and we will continue on. We will soldier on.
Thank you very much for your concern. Mabuti naman po ako. It's actually very tiring for us, for the prosecutors, for the comms, for our talking heads, to be part of this whole process. Compared to our colleagues in Congress, hindi naman po sa panunumbat, no? But as prosecutors and the comms also, the talking heads have been studying actually non-stop since January when the impeachment complaints were filed, tuloy-tuloy po. And now even during weekends, we have to study as prosecutors. In fact, all bought the same materials, same books, so that we could read all of them. Bumalik po kami sa law school, meron po kaming highlighters, nagbabasa po kami araw-araw. And that's what we've been doing lately. So, yes, nabawasan po ang oras namin sa distrito. Ako nabawasan ng konti ang pag-alaga ko ng aking one and only son. And hindi ko na natutukan ng kanyang lessons, lalo na nung towards the end of school. And ngayon, start na naman. But, you know, we always say that we're doing this for accountability for the country, and we know that we will all see it through. And gaya po ng lagi namin sinasabi, para po sa bayan nito.
Maraming salamat po.
Salamat, Isa. Susunod si Willie Delgado from PRTV.
Magandang hapon, no? During impeachment ni dating Pangulong Joseph Estrada, si Attorney Jose Flaminiano, ang naging trabaho niya, objection. May na-anticipate ba kayong ganito since hindi naman direktang sumagot sa mga articles si Vice President Sara Duterte? At kung meron man, hindi ho ba medyo mahihirapan since ang tatay yung presiding officer hindi abogado who can determine kung tama o hindi yung objections?
Kung ina-anticipate namin yung objections, definitely. Because that is part of the rules on presentation of evidence. Meron tayong rules on admissibility, competency, no? And these are grounds of objection. That is innate in every presentation of evidence now. To your question kung mahihirapan ho ba ang presiding officer who is a non-lawyer, that is the point. When I said earlier that this should be substance over technicalities, because this is not a purely legal case, therefore, dapat i-relax ang technicalities to pave way in ferreting out the truth. Because what is important in this trial is to be able to show kung ano ang totoong pangyayari, which will guide our senator judges in deciding whether to convict or to acquit.
Okay. Doon po sa threshold, kung bababa yung numbers na magko-convict, makakasama din ho ba dyan yung mag-a-acquit, yung number na mag-a-acquit?
I think the constitutional provision is on the conviction only, no? So any occasion which will not result to 2/3 of all the members of the Senate should result to acquittal, regardless of the number. Regardless of the number, basta hindi mo maabot ang 2/3 of all the members of the Senate, regardless of how we interpret all, no? Basta hindi mo siya maabot, that is automatic acquittal.
Alright. Kaya kung Zia, yung idea na gumamit siyang local dialect, kasama rin ho ba yung possible na idea na even dun sa mga may hearing impaired, isama rin para maintindihan nila?
I think we have to be more inclusive, diba? This is for the nation, this is for the people, this is for our country. So everyone, all sectors, not only language barrier, but even those who have difficulty expressing themselves through a spoken language, no? Yes.
One last point. Magpapatawag po yata ng special session ng Pangulong BBM sa June 17. Any comment? Any reaction?
Well, we understand that the purpose of the palace is to give opportunity to the Senate to finish the priority measures, which Kong Zia mentioned already, the LEDAC measures, no? I can state for the record na itong lahat ng ito ay approve on third reading na, transmitted na ng House of Representatives to the Senate. So for that to be able to become laws by way of action of the executive or the president, dapat gumalaw din ang Senado. So that's what I read from the notice of the Office of the President about this special session to be held on June 17 now. Now with regards to the issue on leadership, this is just our opinion that sana they take advantage of that special session to address what needs to be addressed, to fix what needs to be fixed, no? And ultimately, to have a duly elected Senate President.
Thank you, Willie. Marian Enriquez from TV5.
Ma'am, para sa inyo. Hindi, kasi po, you were saying, yung gusot po sa Senate, Kung Adiong was saying that's entirely for the Senate to decide, Kung Luistro said, we can only hope and pray, but you've already emphasized several times po yung significance ng constitutional mandate ng Senado. And you also mentioned earlier na you hope magkaroon na sana ng duly elected Senate, President, kasi the reason we are apprehensive, we might encounter another constitutional issue. We will be starting the trial and there is no duly elected Senate President. So gaano po ba ka-importante na hindi lang po we you know, it's up for the Senate, na dapat i-prioritize po nila yung pag-elect ng duly elected Senate President before even yung pre-trial po ay mag-umpisa?
The reason why we are only expressing our position on the matter is because the doctrine of political question applies to the Senate. Matters concerning the power which is exclusive to the Senate, so long as there is no issue of grave abuse of discretion and lack of jurisdiction, is a non-justiciable issue. Kung non-justiciable siya, hindi pwedeng pakialaman ng Supreme Court, lalo na hindi namin pwedeng pakialaman. This falls within the exclusive purview of the Philippine Senate. That's why ang kaya lang namin gawin is to express our position about what I perceived as irregularities happening in the Senate. Now you're asking, how important is this? This is important because impeachment trial is a constitutional mandate. We have witnessed already what happened in the first impeachment. That was during the 19th Congress, while almost all the members of the House of Representatives are of the opinion that the process was legal, valid, legitimate, but nonetheless, it went on with the Supreme Court declaring its unconstitutionality, no? And it is because of issues like the lack of notice and hearing before transmitting the articles of impeachment to the Senate, which is not even mentioned in the rules of impeachment of the House of Representatives, neither in the Constitution. And yet, because of due process, the Supreme Court resolved that the articles of impeachment and the proceeding are unconstitutional, no? Now, we will be proceeding to the schedule of our impeachment trial. We understand that the head of the Senate is a Senate President, and based on the rules, if the impeachable official is not the President, they are the presiding officer. That is before the current leadership changed that into allowing the Senate to elect a presiding officer other than the Senate President, no? Which means that this is a very significant position in as far as impeachment trial is concerned, no? While we duly recognize the legitimacy of the current leadership because of the sanctity, solemnity, and sensitivity of this impeachment trial, it is best that we address that need of electing a Senate President before we actually start. But nevertheless, let me state for the record as well, we're submitting to the jurisdiction and authority of the impeachment court. If they refuse to elect and they proceed to having the trial, we will appear and do our mandate of presenting the evidence in behalf of the institution.
So just for the record, the prosecution believe that kailangan nga po i-prioritize, the Senate should prioritize electing a duly elected Senate President.
Yes, sapagkat nakita nyo naman, dito pa lang sa House of Representatives, they raise as an issue the referral from plenary to Justice Committee. They even raised violation of one-year bar rule, di ba? What else did they raise? They raised as well that we have predetermined the impeachment complaints even before the clarificatory hearing in the Justice Committee. They're also invoking the confidentiality in their allegation that we violated the confidentiality provision of AMLAC in spite of the clear exception in the bank secrecy law and the fact that the subject matter of the AMLAC report are bank reports. Di ba? So, what else will they not elevate to the Supreme Court? Kung ito, dinadala nila sa Supreme Court, we have anticipation. We have basis to believe that even the irregularity in the leadership may be considered by the defense in elevating another constitutional question before the Supreme Court.
And kung susundan po yung Avellino Doctrine, tingin niyo po sapat na yung kunyari 22-12 yung boboto for?
While ang sabi sa Avellino Doctrine, no, non-justiciable din ito. But considering that there is an express provision in the Constitution, 2/3 of all, I think this time, when we interpret the threshold for the purpose of conviction, tingin ko lang, papasok ang Supreme Court.
No, but for electing a Senate President.
For electing a Senate President, the Avellino Doctrine should apply also. Diba? Kasi in determining the threshold, we must first determine the number of members of the Senate who are within the coercive means of the institution. No? So, pag gumalaw yung determination natin ng number within the coercive means, gagalaw ang quorum, gagalaw ang threshold.
I think just to, in addition to that, no, I think what, this is how I surmise the explanation of our lead counsel, Congresswoman Jinky. I think it's to the advantage of the Senate if, for the practical purposes, they have already settled the issue of leadership. Kasi what we anticipate, probably, and this has been asked to Congresswoman Jinky earlier, we anticipate that there will be technicalities that they may use in order to probably delay the most important constitutionally mandated job of the Senate now, which is to proceed with the impeachment trial. So they will, probably those who are opposed to the impeachment trial might probably use all possible means in order to delay that. And one of which, as we've seen in the early in this development, when it comes to Senate leadership, questioning the technicality or the legitimacy of the acting Senate President. So we want that resolved, not just for the House prosecution team, not just for the entire Filipino nation, for the impeachment trial to proceed, but for the practical sense that the Senate has already resolved the issue of leadership.
Thank you. Let us now recognize PB Ngulia from Channel 2.
Good afternoon po. Clarification, balik po ako dito sa isasubmit po ninyo na pre-trial briefs today. You mentioned over 30 witnesses. Is it less than 40? Ilan po dito yung hostile witnesses? If you can provide us with
By
that.
over 30, any number beyond 30. Malapit na, konti na lang. You will know.
Pero kung ilan po yung hostile, ma'am?
Ang hostile, you can anticipate already that this will be officials either from OVP or DepEd, no? I think most of them you've seen already in the inquiry in aid of legislation by the Committee on Good Government and Public Accountability, then presided by Chair Joel Chua back in the 19th Congress.
Okay. And then dun sa order of presentation, for soundbite purposes lang po, ano yung naging basis po ninyo for that order of presentation na nilagay po ninyo sa pre-trial brief?
Well, our consideration is, one, is yung interest ng mga tao. That's one, di ba? Two, yung dami ng ebidensya. And three, yung significance sa ating national government.
But safe to say, hindi yung order na Article 1 to
Not necessarily. Sa ating articles of impeachment, our Article 1 is confidential fund. Article 2 is unexplained wealth. Article 3 is bribery. And Article 4 is threat. Definitely, the presentation will be different.
Okay, and then you mentioned kanina that the Avellino, the SC decision on the Avellino case should also apply in the threshold for a conviction. Will the prosecution make that motion before the impeachment?
We will have to talk about that, no? Hindi pa namin napag-usapan yan as a team, although I understand if when I am watching their interviews, it seems to me that the team shares the same opinion.
But are you open to it?
Yes, we can definitely discuss it among ourselves and perhaps come up with our one position with respect to the question on threshold for the purpose of conviction.
And then, ma'am, on the perception that case, posibleng mag-file na lang ng mga reklamo against senators who are perceived to be allies of the Vice President to lower the threshold, what can you say about that?
Ang alam ko, even before this impeachment trial, members of the then majority, now minority, really have issues concerning graft and corruption or plunder, no? So I do not subscribe to the belief that the reason why there are filing of cases is because of the impeachment. Because the truth of the matter is, may kaso na sila bago pa ang impeachment na ito.
How about on the perception that the Avellino case refers to the legislative functions of the Senate, and this is impeachment trial, so sui generis, as we have always mentioned?
Well, if it will be considered as function of the Senate, which means it falls within the purview of their exclusive prerogative, it only means that it will be interpreted among themselves, whether the Avellino doctrine will be applied as well in the threshold for the purpose of conviction, no? Dapat sila yun. Sila yung mag-resolve. The same way na itong issue of leadership ay hindi ginalaw ng Supreme Court because that is a doctrine of political question, no? But this is very significant, no? So kung hindi sila magkasundo, this is just my position. I hope na bigyan ng pagkakataon ng Supreme Court, ma-enlighten ang Senado about that.
I think mayroon lang ako i-add doon, no? Kasi we're talking about quorum. I think ang naging isa sa magandang dulot ng pagiging House prosecution part ng Coms team is that I was started also to research. No, I think meron ng mga ruling ng Supreme Court, yung Halos-Hos versus People versus Halos-Hos. Yes, Trillanes versus although these are applicable on the Senate functioning as a legislative body, sinasabi doon they can propose actually but they cannot vote. But when it comes to the actual impeachment trial, let's again go back to the issue of the indispensability of the presence of a sitting senator judge. So yun ang premise namin. Paano ka huhusga sa isang bagay na hindi mo nakita, hindi mo narinig, hindi mo nahawakan, hindi mo actual na narinig sa mga testimonya ng mga witnesses, which again is not opposed to the Avellino doctrine, which is not opposed to our position that the Senate has to be also functional, which is not also opposed to the issue that we are trying to brought out na ang Constitution, it has to go hand in hand with the experience of man.
Huli na lang po, did the prosecution receive any other communication from the Senate or from another faction of the Senate?
Except from the notice for pretrial conference, none yet. Wala pa po kaming nare-receive na iba.
Thank you po.
Thank you, Vivian. We will now recognize Gidea Bernardo of D8TV.
Follow-up lang po yun sa akin. Good afternoon po. During the conference last week po, we've mentioned that there is an overwhelming, they keep on coming, the private prosecutors po. Do we have a specific targeted number? Kung ilan lang po yung pwedeng sumama sa prosecution team? And if there is a specific number, how are we screening them? Do we screen them po ba?
Ideally, it should be identical to the number of the public prosecutors. Remember, we are 11, no? So ideally, 11 din yung private prosecutors. We have introduced 10 already. But certainly, those who will not be entering appearance before the impeachment court will still be part of the team because significant yung preparation before trial, no? So, to your question, kung paano ba ito dinidetermine? First and foremost, dapat they share the same position as ours, di ba? Second, dapat pro bono dahil walang pambayad ang mga public prosecutors. And third, of course, we consider the competence. And so far, from the first batch, nakita nyo naman, lahat abogado de campanilla ang private prosecutors who are joining the prosecution team.
Last na lang po. The next batch, will they be introduced before the trial July 6 po?
I am inclined to introduce all of them before we start the trial.
Thank you po.
Thank you, Judea. Thank you for waiting. Red Mendoza from Manila Times.
Hi po, good afternoon. Una po muna yung sa mga private prosecutors, hindi po ba lahat sila mga anti-Duterte? Mga galit kay VP Sara? Kasi halos lahat sila puro mga galit kay Vice President Sara Duterte. What's your thoughts po sa mga private prosecutors na lahat po sila ay mga DDH or diehard Duterte haters?
We have said this before, and we will say it again. This impeachment trial is not about personalities. And I think the private prosecutors, beyond the personality, stand for accountability mechanism, no? Hindi ito tungkol kay Vice President. Tungkol ito sa accountability mechanism na dapat ipatupad whenever there are erring public official.
Pero sabi po kasi ni Attorney Kapunan sa introduction ng press release na wag daw maniwala sa press release ni Vice President Sara Duterte or sa kahit na anong supporters po niya. Hindi po ba parang kinokontrol nyo ng prosecution yung narrative na dapat kayo lang ang pakinggan?
That's Attorney Kapunan's opinion. So she has a right to say whatever she wants to say.
Pero do you share that opinion sa prosecution? Kasi she is part of the private prosecution panel na dapat wag makinig kay VP Sara or sa kanyang mga abogado or sa press release.
It is not the official stand of the House prosecution team, neither would it be the official stand of the private prosecution team. It is spoken out by one member of the private prosecutor, a personal opinion, which, by the way, she is entitled to.
You know, we never said that we should not listen to Vice President Sara Duterte or to her lawyers. In fact, we have been wanting them to speak at the Committee on Justice hearings. Hindi ba ilang beses pong tinatawag ang pangalan niya, ilang beses po siyang inimbitahan, ilang beses pong hinihintay namin ang kanyang mga pahayag, ang kanyang ebidensya, ang kanyang sagot sa mga allegations sa kanya sa impeachment complaints. So, hindi po tama na sabihin na kinokontrol namin ang naratiba. Gusto lang po namin, in fact, gusto namin na sila ay magsalita. Ilabas natin ang aming ebidensya, ilabas nila ang kanilang ebidensya.
Pero ma'am, kasi po sinasabi po ng defense team na hindi po sila maglalabas ng ebidensya on the public space. They want to share the evidence sa loob ng impeachment trial sa loob ng Senate. Kaya hindi po sila nagpapatawag or madalang lang po sila magpatawag ng press conferences while sa House is almost the same na parang araw or parang may mga release almost every week about the Vice President, and parang ang dating is the House prosecution is the one controlling the media narrative. Your thoughts po?
Una-una po, simula nung convene ang impeachment court, wala po kaming nilalabas na ebidensya, wala po kaming sinasabi about the merits because as we have said, we're under sub judice. Now, kung gusto po nilang ilabas lamang sa korte, tama naman din po yun dahil sub judice nga, bawal po kami maglabas ng ebidensya, bawal po kami mag-discuss ng merito ng kaso ngayon. And in fact, to their statement that they will just release it at the court, then that's great because we expect them to state their case and to present their evidence if they have evidence.
Red, if they choose to remain silent about all of these things, that's their business. But they cannot dictate upon us not to inform the public of every development that is happening when it comes to the issue of impeachment, because the public deserves to know. They deserve clarity, and they deserve to see the evidence that will be presented in the open court trial. That's their business if they so decide that they will mum about this issue.
Please understand that the House representatives in this impeachment trial is representing the sovereign Filipino people. Impeachment is a mechanism that was given to the Filipino people to go against the erring public official. In other words, the interest which is being represented by us in this trial is not our personal interest, but the interest of the Filipino people. Suffice it to say that we need to share to the people whom we represent what is going on in as far as the preparation for the trial is concerned. This is the people's right to information. That is why we are prompted to update from time to time what is happening with regards to the preparation of the prosecutors. The people are our client here, and they need to know the things that the public prosecutors are doing in relation to this trial.
Last na lang po on my end. Kasi na-mention nyo nga po na na meron kayong, sinabi po ni Kong Terry doon na may mga evidence, yung bank documents, na parang isasamon yata yung mga bank executives. Na sinabi nyo nga po, it's not a surprise, pero it's not a surprise evidence na parang sinasabi nyo na you're going to present it naman sa trial. Pero do you think po ba the defense should also be informed of this so-called evidence during the pre-trial?
Definitely, they will be informed because they will be given copy of our pre-trial brief. In the same way that they will be giving us copy also of their pre-trial brief, no? So to your question, whether the defense will be informed, definitely yes.
The defense lawyers, and in fact the Vice President, are expected to be there at the pre-trial conference. So, kung ano man ang nakalagay po sa pre-trial brief namin, makikita nila yon. At sila din po mismo ay kailangan mag-submit din po ng kanilang pre-trial brief, which we will all discuss at the pre-trial conference on Thursday.
Last na lang po. Of course, nangyari yung kay President Estrada trial, the second envelope thing, the quote-unquote surprise second envelope, and also the Clarissa Ocampo surprise witnesses. Are we expecting mga ganitong sorpresa, like second envelope, surprise witness sa prosecution?
The trial against the Vice President is entirely different from the Estrada trial, no? So, we should not be likening this as often as possible to the past impeachment processes. First and foremost, the circumstances surrounding the set of facts are entirely different, no? So, there will be no surprises sapagkat there's a rule that witnesses who are not named in the pre-trial brief, exhibits which are not marked during the pre-trial, will not be allowed to be presented during the trial. And of course, we will not compromise the necessity of presenting vital witnesses just to be able to to have some surprises during the trial. No, that will not happen because it will compromise our case. So as early as during the pre-trial, dapat ilalatag na lahat ng testigo. Dapat ilalatag na lahat ng ebidensya. Otherwise, you will not be allowed during the trial to present them. And we do not want that to happen.
Thank you, Red. As we wrap up today's briefing, we invite our distinguished guests to share their short closing remarks.
By way of closing, let me mention that today we will be filing our pre-trial brief, which will contain the stipulation of facts, list of witnesses, list of documentary exhibits, proposed issues, proposed trial dates, and we will be filing that later before the Senate Impeachment Court. On Thursday will be the pre-trial conference, and the public prosecutors as well as the private prosecutors will all be attending. Now, as we all understand, the media will not be covering the pre-trial conference as declared by the Senate in their notice of pre-trial conference. But we assure you that as long as we are allowed, we will update the public of the proceedings in the pre-trial conference that we will be held on Thursday. And if that is also allowed, we will share the pre-trial order that will also be shared with us.
Bismillahirrahmanirrahim. Hinihikayat po namin ang ating taong bayan na makilahok, makinig, at mag-update po patungkol dito sa impeachment trial na ito laban kay Vice Presidente Sara Duterte. Tulad po ng sinabi ng ating lead counsel, si Congresswoman Jinky Luistro, ang kliyente po ng House Prosecution Team ay ang taong bayan. Pinag-uusapan po natin dito yung katatagan ng ating konstitusyon na panindigan yung mga tao o elitis ang mga opisyal na may charges na pagkakasala na labag sa ating constitution. So again, we are requesting the public to join our call for for the proceeding of an immediate open trial of the impeachment court. Marami pong salamat. Assalamualaikum warahmatullahi ta'ala wabarakatuh.
In addition to the contents of the pre-trial brief, we want to formalize our discussion also before the impeachment court on whether or not the open rule will be adopted. The possibility of having both Filipino and English become part as official language to be used during the impeachment trial. The position of the House of Representatives that we are inclined to lean more on substance rather than technicalities. And of course, this concern about translation to as many dialects as possible, ito naman ay para dito sa House. We understand that the members of the House come from different legislative districts all over the country, and definitely they are in the best position to realize the objective of having this trial translated into as many dialects as possible. Again, we want all the Filipino people to be involved in this impeachment trial because after all, it is their interest that we represent. So in conclusion, sa buong sambayan ng Pilipino, samahan niyo po kami. This impeachment trial is accountability mechanism which is innate in democracy. Samahan niyo po kami sa paggulong ng demokrasya. Let us uphold the supremacy of the sovereign Filipino people. Para po ito sa lahat ng Pilipino at sa mga darating pang henerasyon.
Maraming salamat po ulit, House Lead Prosecutor and Committee on Justice Chairperson, Attorney Gerville Jinky Bitrics Luistro, Batangas, House Prosecutor, Attorney Ysabel Maria Bel J. Zamora of San Juan, and House Trial Spokesperson Zia Alonto Adiong of Lanao Del Sur for joining us this afternoon. To everyone, magandang tanghali po sa inyo lahat.